We now call the fourth case on this morning's docket. That is case number 119111 in the matter of Brandon W. Dinas. Before I ask counsel to proceed, I'm going to ask, is Brandon W. Dinas now in the courtroom? He was not here this morning for the clerk's call of the cases. He was not here. I think about 30 minutes later, we officially called them. I'll ask again. I don't see any recognition that he is here. Counsel at some point will ask you to let us know what sort of notice of today's proceedings your office gave to Mr. Dinas. So, thank you.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. To start off with, the hearing in this place took place on December 5th of 2017. Mr. Dinas appeared at that proceeding. He represented himself, participated in it. After the hearing panel issued its final report in March of 2018, the Disciplinary Administrator's Office sent a copy of the final hearing report to Mr. Dinas at his office address and at his residential address. Both of those addresses are located in Lawrence, Kansas. Subsequently, we received notice from the post office that the letter sent to his residential address had been forwarded to an address in Colorado Springs, Colorado. We passed this information on to the appellate clerk's office. Once the matter was docketed with this court, the appellate clerk's office sent the citation in the final hearing report by certified mail to the address in Colorado Springs. The return receipt for the certified mailing indicates that Mr. Dinas signed for that document. Subsequently, the appellate clerk's office also sent the appearance letter for today's hearing by certified mail to the Colorado address. Again, the return receipt indicates that Mr. Dinas signed for that letter. Accordingly, I believe Mr. Dinas received sufficient notice of today's hearing. The matter that was heard on December 5th, 2017 involved 6 separate complaints against Mr. Dinas. The panel, I should note that Mr. Dinas stipulated to the facts. The panel issued its decision in March of 2018, concluding that Mr. Dinas violated rules of professional conduct involving competence, diligence, communication, safekeeping client property, termination of representation, expediting litigation, cooperation in the disciplinary process, engaging in conduct that is prejudicial to the administration of justice, also violates Supreme Court Rule 207 regarding cooperation in the disciplinary process, and Supreme Court Rule 211B failing to file an answer to the formal complaint. Again, after the matter was docketed with this court, Mr. Dinas did not file exceptions to the hearing panel report. Accordingly, findings of facts are deemed admitted. Before the hearing panel, I recommended indefinite suspension as the appropriate sanction. The panel, in its final hearing report, recommended a 2-year suspension with the requirement that Mr. Dinas proceed with or have to do a reinstatement hearing under Rule 219. They also recommended that the indefinite suspension begun to run from September 18th, 2017. That was the date that this court issued an order temporarily suspending Mr. Dinas' law license. Because Mr. Dinas has not appeared for today's proceedings, today I'm recommending his disbarment. I believe that based on his failure to appear for today's proceedings, that could be considered an aggravating factor. I would cite this court's decision in Ray Barker, 302 Can 156. It's a 2015 case where the court imposed disbarment based in part on the respondent's failure to attend oral arguments in front of this court.
Just remind me on Barker, what was the panel recommendation?
I believe it was an indefinite suspension.
So it went. And that's what I'm trying to get at. Here you don't. I'm trying to figure out how much to aggravate failure to appear, and I can understand when it's indefinite suspension and you don't show up, you go to the next level. But here, the panel recommendation is 2 years. And so do you think that should play into the fact that you didn't show up? I'm going to have to go back and look, but I kind of remember some other failures to show back before I was on the court, but that I was a witness in, where it went to indefinite suspension from whatever. This is one of those where it was a minor thing, but the guy just never showed up at anything, and it just kept aggravating. But I think it stopped at indefinite suspension. So I speak to that aggravation.
Sure.
Using the baseline of the hearing panel report.
I was prepared for today's arguments to argue still for indefinite suspension. I was going to add to my recommendation that I believe that the indefinite suspension should begin to run at September 18th, 2017, when Mr. Dinas' license was temporarily suspended. And so that, again, that was what I was going to present. But again, based on his failure to appear, I believe that disbarment would be the appropriate sanction. And so I was taking the position of arguing for a higher sanction than what the hearing panel recommended in its hearing report. I believe that at least my prepared remarks trying to justify the sanction of indefinite suspension was based on the underlying conduct. We had 6 complaints that were filed against Mr. Dinas. He essentially abandoned several clients, resulting in harm to them. I should also note that after this court issued its indefinite suspension order on September 18, 2017, Mr. Dinas failed to comply with the notice requirements of Supreme Court Rule 218, and he acknowledged that fact. We had a pre-hearing conference on October 4th of 2017 where he acknowledged his failure to comply with Rule 218. He indicated to the hearing panel that he would take steps to remedy that. He ultimately failed to. That resulted in Judge Peggy Kittle, the Chief District Court Judge of Douglas County, issuing an order under Rule 221, appointing Sherry Loveland to take over Mr. Dinas' practice to make sure that the clients got the notice and the files that they were entitled to.
Counsel,
Go ahead.
I had a couple points. According to the record, he has been suffering, and I'm assuming still suffers from depression.
He presented evidence at his hearing. It was in the form of, it would be Exhibit A, which would be contained in Volume 4 of the record. It was a diagnosis from, I believe, a general practice doctor in Lawrence who diagnosed Mr. Dinas with depression, anxiety, and suffering also from ADD.
Would that be Dr. Sherry Vaughn?
Correct.
Okay. And the second point was, it sounds from your statements that he has not made any effort to contact you or your office about the hearing or the oral arguments today. Is that correct?
That's correct. The last time I've spoken to Mr. Dinas was on December 5th, 2017, which was the date of this hearing.
All right, thank you. Justice Rosen?
Yeah,
question?
a couple of questions. There was a $2,000 amount in the complaint involving TT. That was ultimately repaid, albeit not in a timely way.
It was repaid on the day of the hearing. After the hearing had concluded, Mr. Dinas handed me a check for $2,000.
Is there any other outstanding restitution or financial obligations as a result of any of the complaints?
Not that I'm aware of, no.
Okay. And I'm curious, typically when suspension requests are backdated, there's to be retroactive from a temporary suspension or some other reason. There's an understanding that perhaps it's suffering from, there's other contributing factors that's at play here, and here there's depression, but he really has taken minimal action to address his depression compared to at least others that appear before us. Is that accurate, or how would you characterize his efforts? Because to me, and I understand he's depressed, so he's not going to be highly motivated to do it, but he went to a couple of KLAP meetings. He did a couple of therapy sessions. He's trying to self-cure. Any other things that he's done? It just seems to be minimal, and I'm wondering why the efforts to make it retroactive in the first place.
My impression too, at the at the hearing was that he had taken some steps, but were not as many steps as I would have liked for him to take to address his depression and his other mental health issues. As far as making it retroactive, I believe that, again, Mr. Dinas he agreed to a voluntary temporary suspension of his license in exchange for my agreement to continue the hearing from October 4th to December 5th. And so I believe he should receive the benefit. There wasn't a criminal conviction that would have forced his license to be temporarily suspended.
Okay, thank you, Mr. Vogelsberg.
Any further presentation?
I have none.
Any more questions? I see none. Thank you, counsel. Court will take this matter under advisement. That concludes